Okay. Okay, so basically for today's topic, I'll be covering from the jurisdiction of courts up until summary trials. Okay, I hope we could finish it timely.
Bro,
Okay.
can record. Record. Have you pressed?
Yeah, I think we are recording now.
Okay.
Okay, so the most important part would be to understand the whole syllabus of Criminal Procedure Code. It is a very interesting subject indeed, at least for me. But it is very tricky at times. So you see, I split it into 18 chapters. You have a jurisdiction of courts up until the High Court power of revision. Okay. So we will try to cover until chapter number 9. Okay. Okay, so okay. Criminal procedure. Let's start from the very fundamental. What is criminal procedure? It is basically a set of procedure used by the police during from arrest, investigation, receiving an FIR, up until prosecution. Okay, and of course, this CPC for CLP, it covers also sentencing and appeals. However, the important parts would be the beginning chapters, for example, police investigation. So let's start from here. I would like to give you a general overview of what CPC is. It's about the subject matter. Okay. So first of all, we have this FIR here. We have types of offenses and remand. This one, I believe everyone is quite well with. Okay. If you don't know what is FIR, it's the police report in short. Okay. And subsequently, we do have arrest, search, and seizure. Seizure is not epilepsy. It's like, confiscating something. If you tell seizure to Dr. Chee, he'll be telling you it's epilepsy. So search is divided into a few, I would say, sectors. There's a search in person, search of persons, and also search of premises and so on. We'll go into detail shortly. Arrest. What is arrest? There is 15.1 and also Shaban, and also actual and constructive arrest. Why is arrest important? We will come into it shortly. Powers of public prosecutor. What are the powers of PP? They have to institute the proceedings, they can discontinue, and so on. Okay. Pre-trial conference. It happens when the representing lawyer, the defense lawyer, is actually having a conference with the PP in order to reduce the charge, to have a letter of representation, and so on. Okay, during pre-trial conference. Charges, meaning that someone is charged, you do have charges, and there are technicalities to the charges. Okay. Subsequently, we have courts, High Court, Sessions Court, Magistrates Court, and Court for Children. If you ask me which is important, I would safely tell you that every of these courts, the chapters are important, especially CFC, Courts for Children. This chapter actually came out during my year. Okay. Okay, whenever someone is charged in a court, you read and explain, and whether or not they plead guilty. If they plead guilty, okay, there is a bail, transfer proceeding, letter of representation. Actually, letter of representation, it can be done anytime. Anytime. Before sentencing, it can be done. Okay. If it doesn't plead guilty, so we go to opening of the cases, this EIC, cross-examination, then re-examination. This one, I believe everyone is also very well versed. And whether there's a prima facie case. And finally, we go to the sentencing. We have aggravating and mitigating factors. And lastly, we do have appeal and revision. This chapter, I believe most of the students are quite worried about. Never mind, let's see what we can do. Okay. So first of all, I would like to go here first. Okay, for the jurisdiction of courts, there are two statutes which you should keep in mind. One is the Subordinate Courts Act 1948. Another would be the CJA, Courts of Judicature Act 1964. So why should we understand about jurisdiction of courts? Okay, because there are some circumstances. The question will be asking you, this case carries how many years and where should it be tried? Okay, this particular case. So you see, there's this first class and second class magistrate. You can actually neglect what is second class because it's no longer practical unless you want to do an essay on it. Then you have to write about it. Other than that, no point lah. Okay, and for first class magistrates court, meaning that the magistrates court, we have to look into the trial jurisdiction and also the sentencing jurisdiction. What is the difference? What are the differences between these? For trial jurisdiction, meaning that for what cases they can hear. Sentencing jurisdiction, meaning that what sentence can they impose in maximum. You see, for magistrates court, even though it can try a case not exceeding 10 years, meaning that it can be up to 10 years. However, the imprisonment which they can sentence is not more than 5 years. You see, you get the point, right? It can hear cases with sentencing up to 10 years, but can only sentence to 5 years of imprisonment. The fine not exceeding 10,000. Whipping maximum 12 strokes, okay, or any of the above. However, there is an exception. Whenever the statute grants them the power, they can actually exceed the sentencing jurisdiction. You can see on my slide as well. Or the accused has previous conviction in the case of EP against Tengku Hitam. Okay, I believe everyone is well versed with the case as well. When we go to this sessions court, I believe everyone is well versed with the hierarchy of the court, so we don't have to go into the basics. Sessions court, basically we can try all offenses except punishable with death. So this one is 63. Just now this one is 85, 87. These are 63, 64. Keep them in mind. What if you forget? If you forget, never mind. Okay, so long as you remember what is the maximum and the what we call that? This trial jurisdiction. Okay, sentencing. You can sentence any except death. Okay. See Dr. Chee having this in the chat box. Is it? It's okay. So for High Court, actually all cases, including death penalty, sentencing as well. Okay. Court of Appeal, hearing the appeals from High Court and all the subordinate courts. Federal Court, you know, right, the two-tier appeal. Meaning that if you start at these subordinate courts, for example, sessions or magistrate, the most you can go is Court of Appeal. But if you start at High Court, the most you can go can be up to Federal Court, question of law. Okay. And after understanding the trial and sentencing jurisdiction, we look at this local jurisdiction. There have been students asking about this. What is local jurisdiction? Basically, it's very simple. If you committed an offense in Kuala Lumpur, for example, Bukit Bintang, you go and stab someone in Bukit Bintang. So basically, you'll be charged in the KL court, of course. Yeah? So you'll be charged in the Mahkamah di Kuala Lumpur. Meaning that every offense conducted locally, you'll be charged at the court there. Okay. However, there are certain exceptions. Okay. 122 to 127. First, I would like to go into detail and explain this. I will take some time. Please bear with me because I want you all to have a greater understanding. Oh, okay. My voice is okay because someone is saying that I'm not speaking loud enough. Okay, this way. 122 says that accused may be tried where the act is done or where the consequence ensues. Meaning that if you stab someone in Bukit Bintang, then you chase them down to Malacca, then the person died in Malacca. So you can actually be charged in Bukit Bintang or Malacca, okay, where the consequence ensues. The second one would be accused may be tried where the act is related to another offense. You snatch someone's purse, okay, in Bukit Bintang. Subsequently, you go to Malacca, you snatch another purse in Malacca. So, see, it's related to another offense. You can be charged at either place. Okay. Third exception, accused may be tried where he escaped or where he was arrested. This one's self-explanatory. Where CBT was committed, criminal breach of trust, or where he received the property. Okay, this one is also self-explanatory. Subsequently, we have where the property was stolen or where he received the stolen property. Where the scene of offense is uncertain. This one, it happens normally to those suspects, wanted suspects. The scene of offense, they are uncertain of where he actually committed certain crime. Okay, so this falls under the exception as well. For 126, where the offense occurred in a journey, it may be tried where it was committed. This one is normally like, cross-state, cross-border crimes, self-explanatory as well. If there is doubt, HC, High Court may decide which court accused is to be tried. Okay. This one, of course, self-explanatory. So whenever you forget, flip your CPC, 122 to 127, the answers are there. Okay. So whenever the question comes out this way, you define section 2 CPC. Okay, section 2 CPC. What is local limits of jurisdiction? Subsequently, you substitute the facts and put in the exceptions. This is how you are going to tackle this kind of question. So for appellate jurisdiction and inherent jurisdiction, I'm not go into this further. Okay. Dr. Chee, are you there?
Yeah. Here.
Yeah. Do you have anything to add?
I think should be okay lah. I think should be okay. Be familiarized with CPC lah. I think that's all.
Yes, correct. So we go to the next one, arrest. So this one probably, can Dr. Chee cover for me? This one, powers of arrest.
Which one? The power of arrest.
Yes, powers, powers of arrest.
Ken, you want me to read the slides for you or how, bro?
Yeah, you can cover, bro. In your way.
Okay.
No problem. Yeah.
Okay, so I think you need to flip the slides a bit for me lah.
Okay, can, please.
Because I don't have this slide with me,
Okay.
Okay, basically, the power of arrest is actually you flip into section 23, 24, as well as 27. These are being the three most important provisions under CPC that talk about the power of arrest. So the section 31 by Magistrate and Justice of Peace, JP, is no longer relevant, pursuant to our past year question. So we'll talk about the power of arrest for police officer. The most important one will be section 23 as well as section 24. Okay, you look at your section 23 per se. Right. Okay, it provides the situation whereby the police or the penghulu, like ketua kampung, but usually the question will ask you the police, seizable offense, whereby this the police officer can actually arrest without a warrant. Okay, you must be familiarized with the situation ranging from section 23, subrule 1, subrule A to number K. Okay, I'll just briefly say lah. The most important one being section 23, subrule 1, subrule A. Why is it so? Because this has been one of the favorite question in which I just read it for you. Any person who has been concerned in any offense committed anywhere in Malaysia, which is a seizable offense, where you can see the definition of seizable offense is you should refer back to your section 2 CPC definition, okay, the interpretation part, okay. Under any law enforced in that part of Malaysia in which it was committed or against whom a reasonable complaint. So you see the first keyword here is a reasonable complaint. So you have several case law like Tan Kai Tak or Shaban, okay, that talk about a reasonable complaint, okay. And then subsequently, you must also state the second requirement, which is the credible information, okay. That means the police receive some sort of valuable information from an informer or party pertaining to this seizable offense, okay. And then the said information must be able to cast certain reasonable suspicion among the police officer in order for arrest to happen. This is how the whole story must go lah. Because to arrest a person, a lay person, is actually refraining his liberty towards the life, So CPC provision is very interesting lah. If you study it by your heart, I can sort of assure you that you'll learn that there are some threshold, towards the arrest, okay? So section 24 provides the condition where the offense itself is a non-seizable offense. That means a less serious offense, but still the police can bring the person to this police station, which amount to an arrest lah. These are the situation whereby if you read your section 24 closely, only a few situations where the person is like refusing to give the name, the residence. That means the IC lah, IC not given to the police. You are being not very cooperative. Okay. Otherwise, second situation would be if the person had given the name and also the address, but the police had reasonable belief that the said information are actually false one, that person is lying, So actually the police can hawk the suspect to the police station by this section 24. Okay, section 24. Section 27 is the provision of arrest, for ordinary people, just like you and me. We are not police officer, or we are not the so-called authorized officer under the act to arrest or to refrain somebody's freedom, correct? So we rely on section 27 in order to make an arrest, because we have to practice like a good Malaysian citizen, in which we have to have some, good Samaritan spirit, correct? So this section 27 provides and enable us, enable us, the private person, to make arrest, but there are some criteria for you to fulfill as well. So the first keyword here, I think, is in his view. That means either in my opinion, or I saw some crimes have been ongoing, okay? That a person commits non-bailable and seizable offense. So you must be very careful, not just some light crime, It is a very heavy crime, for example, a theft, a snatch thief, or somebody is trying to murder somebody. Yeah, that time you can step in and help, okay? So this is how lah. And then after the said arrest by private person, I think I should add in that you have to bring the person back to the police station, the nearest police station, so that the arrest can happen. Is it okay? Bro, can.
Thank you, Dr. Chee, for the kind explanation. Yeah, for this kind of arrest, one more point I would like to add, other than Dr. Chee's kind explanation, will be what is seizable and non-seizable. You can actually flip your CPC. I believe every of you must have known about this. You flip to, I'm using this digital CPC because I hate physical books. Okay, you can flip to page 219 of the CPC. Okay, 219. So basically, you can see there is this first schedule here. So if you're from here, you can see whether the offense is bailable, non-bailable, compoundable, okay, or whether a warrant of summons should be issued. Okay, everything is there. Subsequently, we go to this mode of arrest. Why should we know about when the arrest is effected? Because in certain cases, for example, 39B, MACCA, and so on, see, flip to my notes here. It is important to know whether the arrest is actual or constructive, because caution needs to be administered before effecting an arrest under offences for DDA, MACC, or Kidnapping Act. If an arrest is effected and caution isn't administered, statements after the arrest is inadmissible, meaning that you have the right to decide to remain silent after being arrested. But if they don't give a caution statement, so your statement is inadmissible because you do not know when are you being arrested. So remember this, this is the point, the purpose. Whenever we learn something, we should know the purpose, I believe. Okay. So for the mode of arrest, there are two types. One is statutory, 15.1, actually touching the suspect, confining, submission to custody by words or action, meaning that you are being arrested. Okay. Whereas something which is not covered in the statute, we look at this Shaban case. It's a common law case. It states in terms, meaning that you have been arrested. Uses force to restrain, meaning that probably you handcuff someone, and by words of conduct, that necessary force will be used. Stop running. You are under arrest. If not, I will shoot. Okay, this kind of words or conduct. Okay, so degree of force. This one would be this, because when you arrest someone, of course, you have to handcuff them, you see. So when you arrest them with force, what kind of degree can you go up to? For these offenses which carries death penalty or life imprisonment, you can actually up to the force of causing death. But of course, this causing death must be justifiable. You cannot see a drug dealer and simply take a gun out and shoot him. It just doesn't work that way. You have to be justified, okay, in a way. Under 15.3. For 15.2, it would be reasonable force. The word reasonable force. Okay, so we look at a few cases. I'm sorry, it's been just a minute. Okay, we look at a few cases, okay, whereby actual arrest and constructive arrest. I would like to look at the case of Lee Che-ju against Muhammad Sharif Othman. You just write Lee Che-ju, enough is enough. Huh? Don't have to go too long for the cases. So this P claimed that actually is an accused. The accused claimed that he had been wrongly arrested and detained at the police station. So the court held that there was no arrest as he was only asked by the police to wait. The willingness to wait is not equivalent to being put under arrest, because there are circumstances where the police ask you, duduk luar tunggu saya 2 hours, 3 hours, it doesn't amount to arrest. Okay. Looking at the case of Tan Seo Chuan, okay, this case held that accused was under arrest as soon as the police showed his authority card and the accused was guarded by a corporal. This amounts to arrest. So you just remember these few scenarios, because exams, I'm not saying they're 100%. There are circumstances where they will substitute the facts of these cases into the exam question. So when you read the exam question, it is arrest chapter, and you can cite the relevant cases accordingly. Let's look at the case of PP against Saleh. Yeah. Only under constructive arrest at the time statement was made. Actual arrest only took place when he was taken in. Thus, it was unnecessary for PW3, is prosecution witness normally is the police to administer the statutory caution, which we discussed earlier, since there was no arrest. This one, Tan Chai-ju, he was not free to go, doesn't mean that he was arrested. Okay, because when the police is searching, everyone is actually must be present there. You cannot walk out of the premise or so. Okay. So this is a Tan Chai-ju case. Okay, this one is very, very important. Everyone has to pay certain degree of attention. Article 5.3 and Section 20A, sub 1, provides that a person arrested without being told the reason, okay, you can read, meaning that a person who is being arrested, the rights of the person can be informed the grounds of arrest. Whenever someone is arrested, okay, there's a right to legal counsel, under Article 5.3 Federal Constitution and also 28A. Okay, this one you can keep in mind. Okay, you can keep in mind. Normally, in real life situation, when someone is arrested, unless there is a risk of tampering of the evidence, or maybe they will go and ugut the saksi. So normally they have the right to their counsel, legal counsel, and they can actually call their family, notifying that they have been arrested, unless it is a grave crime. Can this be rejected, this right? Yes, the answer is yes, but by a police officer of Deputy Superintendent of Police, DSP and above. Okay, DSP above. So you need DSP to reject this right. Okay. So whenever someone is arrested, of course, you cannot close them out. You cannot detain them for more than 24 hours. You should bring them to the magistrate's court, or the word is actually before magistrate, not the court. Before magistrate, meaning that anywhere, it's not only the magistrate's court. In practice, anywhere where the magistrate sits within 24 hours, then you need to bring them to this in front of a magistrate. Rights to remedies for wrongful arrest and detention. This one would be, for example, he was wrongly arrested, maybe they got the wrong person, they both look alike. So this one you can file a civil action for sure. Right? After you are out, not when you are inside. Okay. And the writ of habeas corpus. What is the writ of habeas corpus? There are some cases, this arrested person, we don't know where he or she is, okay, for some reasons. Okay. Whenever we don't know where he or she is, whether he is detained under the SOSMA and so on, or this person has disappeared, okay, we can actually apply to the High Court under Section 365, the writ of habeas corpus. The person has to be brought to the court. This is what habeas corpus means. Okay. As you can see, to release a person who is illegally or improperly detained, we do not know where he is. For the, what we call that, these questions, yeah, Dr. Chee is actually answering in the chat box. Thank you, Dr. Chee. We will come back to the question. We finish the slides first, probably, yeah? Okay, the right to remain silent. This one I've mentioned earlier, meaning that you cannot say anything, but in practical, you better say something like you have not if you have not done something wrong. And of course, you have this legal practitioner of your choice, 28A and also Article 5.3. Please keep in mind, this Article 5.3 and 28A is particularly important. This one definitely, I would say, 90% is coming out in your examination. Right to bail. This one will come to it in the bail chapter. Okay. Okay, so this is the search. So when we come to this chapter of search, there are actually three headings, I would say. The first one will be search and entry of persons on premises. Search of body of a person. And also search of place or premises. So a lot of people, including myself, I get very confused, when I was having this exam. Why so many types? How to differentiate? So let's look into it. You see, search for a person sought to be arrested. This one is actually, they are actually going to be arrested, so you have a search on them. Section 16. Search for persons wrongfully confined, meaning that someone, this one is not like searching for item, for searching for a person. Kidnappers and so on, they confine someone, okay, in a barn or yard. So we go in and we can do the search. It's under Section 58, okay? If entry is denied, okay, the question might come out this way. They have been, falsely imprisoning someone or kidnap someone. So this force of police, they are going to have an ambush, okay? Whenever the accused, the suspect, doesn't want to open the door, of course, so they can break into the premise, they can breach the door to prevent the suspect from escaping. This one is 58 and 59, okay? When we come to this search of body of a person, this one I would tell you which to focus on. I'm not saying that you can neglect the others, but you can pay particular attention to some of the sections. Okay, search of persons in places search under warrant. This one is actually quite simple, meaning that whenever they are having a search, okay, in a premise or so whatsoever, you can search the persons present. This would particularly happen during nightclubs, okay, when they ambush the nightclubs, so they will search all the person, whether they are drugs or not. This one is under Section 17 of CPC, okay. Search of persons arrested. They have arrested a person as per we have discussed earlier, actual arrest, constructive arrest. They have actually arrested a person. They can always also search him under Section 20. So this is 17, this is 20. Normally 20 is important, okay? Power to seize offensive weapons, search for of persons for name and address. This one, I would say rarely used, but you can, of course, read your CPC, okay? These are all very self-explanatory. Just that you need to keep in mind one thing. When you see search, you flip, okay? Section 20, you flip to section 20. Okay, this is particularly important, 20A. There are 4 types of body search: head down search, strip search, intimate search, and intrusive search. This one, I believe, pat down is just patting down. Strip will be, a woman has to be searched by a woman. Okay, strip search. Intimate search means they have to strip off everything. Or intrusive search. This one is done normally at the hospital. Okay, the MO will actually do some intrusive search. Maybe they have hidden drugs in their anus or so on. Okay. Okay, so other than that, let's go to this search of place of premises. Can Dr. Chee cover for me for search and place and premises? Yeah.
Oh no, bro, this one I think you are more familiarized. The police investigation probably can.
Okay, can. Then I continue. Okay.
Okay.
Okay, so whenever there is a search with search warrant or search without warrant, you just remember 54 and 62. Okay. You see, there's a question raised why those IOs in the police station, they are normally inspector. Why? Because you see, they can search the place without a search warrant. See, on the right. If he receives information, has reasonable cause to the suspect that stolen the property, meaning that they actually conceal the property at one place, or grounds to believe that by delay obtaining a search warrant, the property is likely to be removed. Actually, in practical, basically everything when they suspect, they can search. This is the power given by CPC. Okay? With search warrant, okay, may be issued when this one, to be honest, normally when you have an inspector, you have information, you are able to do the search. So what for getting a search warrant? In practical, it's not practical. You have to take a lot of time. Then they might be whistleblowers everywhere so you never know. Okay, this is impractical. Section 56, magistrate may issue a search warrant to enter and search the place if he has reason to believe that an offense is committed or an evidence or thing which is necessary to the conduct. This one is self-explanatory, okay? Meaning that if the police actually apply for a search warrant, then they could go in and search the place. This one, the case of Lam Chia, actually nothing much, meaning that there is no very specific time frame for this search warrant. I've asked the police about this question. Okay, if in this case, I see there's a 5 days delay. They gotten on the 3rd of November, but they actually did the search on the 8th. So there's a 5 days. So this one is directory and not mandatory. You can see 57. Doesn't matter. You can use. So long as not 1-2 years, the one a bit absurd, okay? Okay. 63. I believe all of you, you have to understand the ranking of the police officers. From constable to corporal to sergeant, okay, all up to CPO. Beyond the CPO, I don't think is useful for your CPC. CPO is what? CPO is actually OCPD, meaning that every district, for example, Kulai Johor, you have OCPD Kulai. Sedang, you have OCPD Sedang. So the head of the district, OCPD, officer in charge of the police district. Okay, so they can actually get authorization by the CPO, and they can actually search, seize everything inside the property. Okay, so this one, nothing much. These are all what I'm telling is practical experience. I've actually I personally, I went to the CPO, I went to the OCPD, I asked them about these questions. Is it true? Okay, is it this way? Everything here is true lah. Okay, it's true lah. There is this another thing I would like to go into. Wait, okay, seizure lah. 435. Okay. With or without a search warrant, they can seize alleged to have been stolen, suspected to have been stolen, or found in suspicious circumstances, and an offense has been committed. In practical, basically everything. If I suspect, I can seize. Isn't it everything? Yes, yeah, I mean, in practical, it's like that. So such officer, if subordinate to the officer in charge of the nearest police station, shall report the seizure. Those probably, sergeant or maybe constable, they are having they are actually participating in the raid. They should report. Or sometimes you see like constables, they doing this round at this taman. So they stop someone, they see one pack of drugs on them. So they can seize the drugs. And of course, they have to go back to the OCS or whatsoever. They have to officer in charge of the nearest police station. This one is OCS, officer in charge of the station, different from OCPD. OCPD is district level. OCS is actually just the station, balai, ketua balai. Okay. So of course lah, they have to take the pack of drug and go back. Okay, tuan, saya dah jumpa ni barang lah. So section 64, this one is senarai bongkar. This one is particularly important, meaning that if the police okay, breach into this house, they done a raid on drugs. Okay. They found ketamine, they found MDMA, they found heroin, everything. So they have to put in one list, including the handphones, cash, and so on. It's section 64. We call it senarai bongkar in Malay. When they produce it on the spot, then the accused has to sign, meaning that they acknowledge, oh, this list is actually, these belongings are actually under my custody and control. So this one is also particularly important when it comes to this trial. For example, cases of drugs. If they have signed the senarai bongkar, meaning that the evidence is not planted, you see. The items are actually searched on the spot. Okay, section 65, this is nothing much, meaning that probably you rented some property to drug lord, then the raid happens and the police will actually have a copy and show you the copy. No issue. Okay. Okay, I don't think there is anything much for this part. Okay. Okay, this one very important. FIR. Chee can continue for me. FIR.
Can.
Okay.
You're toasting, right? Okay. FIR is like Mr. Gunn had previously said, this is just like a police report. Okay. You must understand that FIR is just like okay, it could be lodged by a few people, like the accused himself they are witness to the crime scene, can also lodge the report, as well as the third party that has no relationship at all with the commitment of crime, or as long as they receive any information, they can actually lodge the so-called police report. This is the so-called FIR. But one thing you must be very sure is that the investigation, usually police will open any information given by the public or anybody to start the investigation of the crime, But this is not always the case. There are some exceptions. For example, without FIR, if the police had suspect a crime, they can actually initiate the investigation, okay, even without the FIR. Like your case, the famous one, Emperor against Hua Jua Nazir Ahmad. Okay. So in order for you to understand FIR better, I think it's better for you to read the section 107 and section 107A in detail. It's very important. It governs that every FIR should be actually reduced in writing and also be read to the informer back. I'm not sure whether any one of you had any experience of lodging this sort of police report. So usually this is the case. You tell the police officer at the counter about what had happened. The officer will type, they'll slowly type in the date, the time, and the chronology of the incident itself, what you have seen. And subsequently, they'll put a full stop, something like that. They'll say, I lodged this report for further investigation. I lodged this report. For example, you got extortion, something like that, to protect my future safety. Okay, to urge the police to investigate into this matter. Okay, so every FIR must be written and read to the informer. Most of the time, the police will print that police report out and then ask you to sign and give you a copy. Okay, I think you can see it in Facebook very often lah. So and so have some domestic violence, something like that. They'll put their police report on the Facebook. Okay, these are the criteria that you must be aware of. And then FIR nowadays is being kept in the computer system. Okay, so the printed one they'll keep in a book as well, and to be signed by the informant, as well as to keep one copy by the police lah. Okay, this is very important. So other than that, what else you need to know about the FIR? You must also get some information that FIR is not everything, it's just the starting point of the investigation. It does not actually bearing a lot of weights in order to establish the crimes of the suspect. You get me? It's like FIR is just the starting point. The police get information only. Subsequently, to establish the crimes of the suspect, you need other supporting evidence, like you need witnesses, you need the weapon, or you need the stolen good in order to support your case during the trial. So FIR is not everything. So this is actually not a privileged document as well. You must bear in mind, because FIR is open. Even the informant can take back a copy, right? So actually the accused is also entitled a copy of FIR. Just think like that. And Section 51A CPC provides that before the trial, the FIR is one of the documents that should be given to the accused. Okay, so for the accused to prepare their defense. Right. After that, we need to note, okay, for example, if you are the informant that lodged a police report, okay, after a while, you need to know what is the status of investigation, isn't it? How the police, which stage, I mean, the police interrogated any witness or not? Had actually go and arrest the suspect or not. So you need to know also. So this is provided in your section 107A. Okay, you have the right to know lah. And in fact, the police actually should have reported to the informant not less than 2 weeks. Okay, not less than 2 weeks. You can see it in your section 107A. Okay, not less than 2 weeks from the receiving the information. Okay, and if the police fail to provide information, or there are some delay in providing the status report within the time specified, actually the informant himself, the one that lodged the police report, can lodge a complaint to PP. Okay, that is pursuant to your section 107A rule 4. Okay, otherwise the police is not moving. You have to urge them to move, right? So this is beyond your power already. Okay. Okay. After getting the FIR, So the investigation officer, we call it IO, Okay, usually the IO in the police station will rank at least they are sergeant. Okay, why? Because they can investigate straight away. Okay, you get me? There must be sergeant and above either sergeant or the inspector Okay, so for non-seizable offense you must look into section 108. Like I said to you just now, non-seizable offense is a less severe offense. So the police cannot simply just go in and harass people, isn't it? Interrogate the witness and go and arrest the suspect, etc. So they cannot do so. They must obtain the OTI, the order to investigate from PP, in order to enable them to do so. Otherwise, whichever evidence that you have collected, or the interrogation, the witness statement, etc., whatever you have collected throughout the procedure shall be deemed illegal. That will cause a lot of problems later. Okay, if the police officer wanted to investigate, like I say, OTI is important from PP. PP must grant the power okay, based on whatever they have collected. If police officer does not wish to investigate, they must bring this police report to the magistrate for further action. If the magistrate also think there's no case at all, they'll put one NFA, no further action. Case closed habis. Okay, so for seizable offense, you must look at that in your section 109. Okay, section 109 provided the sergeant or the OCS, the officer in charge of the police station, can investigate without any OTI from PP. Okay, just now, non-seizable, you must have OTI. For seizable offense, it is a more serious crime. So police that rank from sergeant and above can actually go directly and investigate. That means they can go and interrogate witness, they can go and find further evidence, okay, to investigate this matter thoroughly. Okay. So even though, let's say, for example, this case was investigated by only a lance corporal, it's not even a sergeant. But for seizable offense, you must always remember our policy, Malaysia policy, government policy, and rules and regulations. We want to create a crime-free society. Even though the police has no power to investigate, I mean, the rank is not enough, but it will not affect the validity of the said proceeding, unlike non-seizable offenses. Okay, and if you are not sure, for example, some of the time the informant are very blur, they are not sure what happened. If you do have any suspicion, what you need to refer is you suspect there is seizable offense, but from the information given by the informant, it's not adequate to support that yet. So what you do, you go by section 110, in which if the police suspect this is a seizable offense, again, if you just suspect, the police suspect, what you need to get the power from? PP. PP actually must give consent to you, the order to investigate to the police, so that the police can go further, to take further action, okay, to investigate. All right. And then and subsequently, during the investigation, I think the most important provision will be section 112 and also section 113 law. Okay. So section 112 can be given by the accused or by any witness. And section 112 is subject, you must read together with section 113, in which section 112 is actually what we call is a privilege. It's like a privilege statement, That means to say the police cannot give to the accused during the trial. unless for the purpose of impeachment lah. Okay, this is the thing that you must bear in mind. Okay, so other than that, we have to look into based on the notes here is the remand. No? The remand is section 117. You must read together with your section 119. That is the diary of proceeding. Okay, remand thing is like, okay, police already found a suspect. Okay, and by right, the investigation is ongoing, but cannot be completed within 24 hours. So you wanted to extend the lockup period, So you do not want to let go the suspect yet. So what you can do, you can apply for remand order from the magistrate. That is pursuant to your section 117. Then in order for you to get this sort of remand order, because remand order, the magistrate also need to consider a few things, okay? Whether this is a serious crime or less serious crime, okay? If it is a serious crime that carry imprisonment more than 14 years. That's why whenever you read the question, you must fall back to your penal code section. Okay, you must see what is the maximum punishment under the penal code. If it is more than 14 years, the first remand order is not more than 7 days. That means 7 days max. Subsequently, before the completion of these 7 days, you must apply another second application. This is another 7 days could be given by the magistrate. Okay. And if the so-called the punishment is less heavy, is less than 14 years, the first application should be not more than 4 days, and the second application should be not more than 3 days. So these are the powers vested in the magistrate. Okay, but one thing is the police side who requests for this remand order must produce the investigation diary. Okay, that means what have been done. Okay, why within 24 hours? The magistrate will question himself also and also question the police. Why you cannot complete the investigations within 24 hours? What makes you think that further extension could help in your case? So this is normally what happens in the remand process, And by virtue of section 119, it is mandatory for police to show to the magistrate what had happened through their investigation diary. Okay, I hope it's clear up to this point. Other than that, pertaining to the admissibility per se, okay, admissibility of first information report, like I have told you before, first information report is just a police report. Okay, and so it is kept. Original copy is actually kept in the police station. You cannot bring the whole computer. You cannot bring the whole bundle of documents to hospital, isn't it? To the court, isn't it? During the trial. So what happened? Section 108A provides that a certified copy of FIR actually is admissible, just like original. So there's no argument, pursuant to your section 60 of Evidence Act, right? The primary documents and also your secondary documents. Okay. So other than that, I think I have talked about section 51A lah. Section 51A is just simply before the trial, PP or the DPP must give whatever documents to the accused in order to prepare for their defense. Okay. I think that's all, bro. Is it adequate?
Yes, adequate. Okay, thank you so much. Okay, so actually what Dr. Chee has shared will be very sufficient. Recap, for this FIR can be any police report. Okay, you personally going to a police station, or you see sometimes you in front of hospital, you can see IO going in. Why are they going in? Because they are going to take this FIR from the person who has been beaten up or stabbed in the hospital. So FIR is not only, okay, it doesn't like limit to you personally going to the station and lodge a report. It also permits the police to go to you and take the FIR, because this is first information report. Okay. So other than that, these are seizable, non-seizable. Dr. Chee has said you need OTI for non-seizable offences. If not, that the evidence would be rendered as illegal, illegally obtained evidence. And also for seizable, of course, sergeant and above. That's why, for traffic offences cases, and most of the IOs are sergeants. This is correct. And also the 112, we call it 112 statement. 112 statement will be the witness statement, meaning that this accused can be taken 112 statement as a witness, as someone who is actually lodging the report, okay, can also be taken this 112 statement. We have this question here: does FIR include WhatsApp messages sent to fraud scheme hotline reporting suspected fraud crimes? This one is actually, to be honest, I have no experience on this matter, but definitely I'll check it out for you lah. Okay. Okay, let's go to the next one. Okay, this one will require us to look at this power of public prosecutor. Just now we received one question: is DPP PP? It's actually the same. Don't confuse yourself. It's the same. Sometimes they use DPP, sometimes they use PP. Okay, it's pretty normal lah. So for PP, they actually have this, they are very powerful, okay, in authority. They can institute the proceedings, they can drop the case without any, what we call that, reason thereof, For example, there is a drug case going on, or there is a, any case like murder. Suddenly, the PP can say, oh, I, drop the charge. They can just drop like that without giving any reason thereof. So long as it is before sentencing, before the court sentence, and the PP is functus officio, so they can actually do that. So in this case, you need to memorize this case. Just a minute, let me. Okay, this case, PP against manager of MBF Building Services in Berhad. It held that it means commence. Institution of proceedings means commencement of proceedings. Okay, PP is discretion to institute. Of course, I have mentioned it. It is to actually commence the proceeding. They charge someone in the court. The requirement of consent and sanction. Okay, what is the difference between consent and sanction? In short, consent means something which requires them to, this one, for example, OTI is a consent from PP, right? But sanction, we can see it in what cases? Cognizance of magistrates. Okay, later we'll come to it. That means sanction. Okay. So we have seen they have the power to institute the proceedings. Going back to the general provision of this power, please keep in mind 145 sub 3 of the Federal Constitution. This provides that the Attorney General shall have the power to institute, conduct, or discontinue any proceedings for an offense. See, meaning that they can do anything to any offense. Section 376 of the CPC provides that AG shall be PP, and PP may appoint DPP who may exercise the powers of PP, except PP's personal power. Just now, as I said, in reality, in practical, DPP and PP, they don't have much differences. So don't have to look into that. Okay. Okay. Conduct of proceeding, you see, institute, conduct, and discontinue, right? So for this conduct of proceeding, this one you have to memorize lah, no choice lah. Okay. PP against Dato Haji Harun bin Haji Idris. It interpreted to lead, guide, and manage. LGM. Okay, keep in mind. This one you have to reproduce in your examination. Who can conduct prosecutions in court? This is simple. For example, when you are charged for road traffic offense, kena saman lah, sometimes you have to go to court because you use handphone while driving. So you go there, you can see these JPJ officers sitting there. And they are the ones who has been given power to prosecute. That's all. Nothing rocket science on this. So conducted by private person inspector. This one, to prosecute someone as a private person, I would say it's not very practical in real life. They wouldn't give you the power. I mean, even though it is written so. But this private person may mean senior lawyers, you see. These are the late Dato Sri Gopa Sri Ram has been appointed as PP. So that's probably what private person means. Who can appear and conduct appeals? This one, PP, DPP, okay. Nothing much. Nothing much for this. So just now we had institute. Now we have conduct. And let's move on to the next one. Let me clear all my drawings. Okay. This one is probably going to come out in the examination. Section 254. We recap a bit. 1453 FC, Federal Constitution. 376. See, these PP's powers, AG's power. We have this 254. May, he thinks fit, at any stage of the trial before judgment, they can discontinue. Okay. Get some cases. HLS Pereira. Effect of discontinuance. What happens? When someone is being acquitted of a crime, finish the trial, sentence, not guilty. It's not guilty. You get DAA, discharge amounting to acquittal. What happens when PP discontinue the proceeding? You can get two possibilities. One will be DAA, discharge amounting to acquittal. You are a free man. You cannot be charged again. The double jeopardy rule. Okay. One person cannot be charged twice for the same offense. Or there is discharge not amounting to acquittal. DNAA. This happens when, normally, chemist report not coming out for a few times, we can request for DNA, meaning that the accused is temporarily a free man. Do whatever you want, okay? But normally there's a bond, there's a bail, okay? Discharge not amounting to acquittal. If they found new evidence, new witnesses, they can charge you again. Or maybe the chemist report comes in the next sebutan, they can charge you again. You are not a free man yet. This is DNAA. Okay, this one clear. Normally, in practical, this is correct. When PP discontinues, they drop the case, they'll go for DAA most of the time. Most of the time. Because no point. You have the power, you drop the case. What for DNA? Are you going to charge me again? That is not logic. So normally they go for DAA. Okay? So the person is forever a free man. They have so much power, see. So when it comes to these miscellaneous powers, withdrawal of remaining charges. This particularly happens in drug offenses, and also probably they rob someone. Okay. They are charged with this 39A, maybe 51. Okay. So they have pleaded guilty to their drug offense, but there's one robbery pending. So if they have pleaded guilty for this drug offense, PP may withdraw the remaining charges. This is actually, again, the discretion, the powers of the PP. Don't confuse yourself with this one. Nothing much. 171. Subsequently, the power to issue an order to investigate, OTI. as seen in the non-seizable offence. When you lodge a report, FIR 107, what happened next in practical? Sometimes we just incorporate the practical scenario, then you can understand more in your examination. You'll be called to the IO, called by the IO. You take 112, correct? After taking 112, or even before, sometimes, the IO will say what? Ini saya tak boleh ni lah, tak boleh siasat lah. Tak ada, no criminal element. Okay. This is a non-seizable offense sometimes. Sometimes, they will tell you to RTM. Ini tak boleh lah, ini kita RTM. RTM is refer to magistrate. We'll come to this later as well. So, as mentioned earlier, they have this power to issue OTI. In reality, OTI, I've asked the OCPD before, how easy or how hard is it to get? Sometimes it's just one call away. And also subsequently, they have these powers to transfer cases to the High Court. 418A and 418B. They may issue a certificate to transfer. Okay. This one normally, for example, for drug cases, 39B lah. It is charged in this, normally it's charged in these subordinate courts first, for sebutan and all this. Subsequently, they have to be transferred to the High Court, right? Because it carries a death penalty for 39B. So the PP may issue a certificate lah. They can transfer the case. Deny the bail. This one not very practical. I mean, like, doesn't come out too often. Okay? So you can skip this. Save some time. Transfer of cases. Okay. This one, nothing rocket science. Quite simple. Magistrate or Sessions Court, vertical transfer. Vertical transfer, different powers, but same local jurisdiction. Mean that you go up. You transfer. Magistrate transfer sessions, session transfer magistrate. Okay. For this lateral, similar powers but different local jurisdiction. Meaning that you transfer to other states, transfer other district, and so on. It happens. So High Court 417, and also we have two limbs. The grounds to transfer, the first one, first limb. The High Court is here, may on this initiative to transfer cases to or from lower court. Number one, first limb, a fair and impartial trial cannot be held. There are some, it's not impartial, the trial. It's not fair. Question of law or unusual difficulty is likely to arise, meaning that the subordinate court, with due respect, might not be able to hear the case. Place in or near any offense which has been committed, they can transfer the case. General convenience of the parties or witnesses. This one is normally upon this request of PP or the defense counsel, or expedient for the ends of justice, meaning that for justice. Vertical or lateral transfer. So this one you may read on your own for this 417. Other than the courts having this power to transfer the cases, public prosecutor, as mentioned earlier, has also the power to transfer cases. 177, you see, if or before or during trial, PP can apply to the lower court for the case to be transferred. This one is by application. See here. 177 and 417 is different, and 418 is different. See. 417 sub 2 says that PP can apply to the High Court for the case to be transferred. Okay. This one, 418, is an issuance of certificate. They can transfer the case to High Court. Okay. Okay, this one, 177A. The consent of the PP must be obtained to institute prosecution in the High Court. Once consent is obtained, magistrate must transmit the cases to the High Court after the charge has been explained to the accused. This one is pretty self-explanatory. Okay? Other statutes, so nothing quite important here as well for these other statutes part. So let's have a recap here. Okay. Magistrate and Sessions Court, we have vertical transfer and lateral transfer. See, 177, 417. High Court, we have 417. PP, this one is particularly important. 177, 417, 418A. 418A states that they can issue a certificate to transfer to the High Court. Okay. So I think I've covered these transfer of cases. Okay, this is what I mentioned earlier. RTM. They always say like, this one is a cognizance of a magistrate. In practical, when it happens when the police doesn't want to investigate, especially for a non-seizable offense. Okay? So, Dr. Chee, cover a bit for me on this. I believe you are well versed on this one.
Okay, this is just like a private prosecution, you know. The police think that the case is very light and then subsequently refer to the magistrate. So magistrate should decide whether, how to say, to go on or not. So these are the provisions that from section 128 to 132. So these are the procedures that adopted by the magistrate pertaining this sort of so-called private summons lah. That means, for example lah, I take the section 323, easy, voluntarily causing hurt lah. I hit Mr. Gun. So Mr. Gun report. Subsequently, this is a non-seizable offense, isn't it? The police not planning to investigate because my so-called the injury is not serious. So they refer to magistrate. So these are the procedure that adopted by magistrate pertaining to the matter. So section 128 provided that the magistrate must take note lah. That means take cognizance of this the occurrence of this sort of offense. How they take cognizance, there are actually 4 situations. Number 1 is open receiving a complaint like from the police law. Okay. Second, open his own suspicion also can. And sometimes it's from the lawyer also. I engage with a lawyer. No, Mr. Gunn engaged with a lawyer because I hit him. Police he lodged a FIR, police does not want to investigate. So he engaged a lawyer to sue me. He doesn't want to sue me in court, you know, in civil court, you know. He wants to sue me so that I can go to prison. This is by criminal procedure. We call it private summon. So this is one of them. And as well as the magistrate had the jurisdiction to try this matter before him without any custody process lah. So this is what it means. And then section 129, I think is particularly important here because magistrate by right is the judge, correct? He's just the so-called the magistrate court judge, correct? So actually he does not have the power like police or the PP, you know. So PP charge criminals in the court in order to prosecute him. So in order for this private summons to go through, there must be some power conferred to him. That means the sanction. PP must have agreed, okay, magistrate, you go ahead. This is my written sanction. I hereby agree that, okay, you can investigate this case. So section 129 is very important. Otherwise, magistrate cannot proceed without this power. Okay. And then section 130, if there is a complaint from PP, that means PP already complained to himself. So no written sanction is required anymore. And then the court, actually no court shall take cognizance under the offense. The written offense here is actually what we call, except for section 127 or section 128A, section 298A, or section 505 of Penal Code. Okay, this is one of the provision here. And like just now, section 131, the complaint can be by the person aggrieved as well. Okay, but you have to see you have to see the details of the information. It can also be the complaint by the husband as well. Husband as well. So after that, what are the procedures that the magistrate must take after he knew about the offense? This is provided in section 133 to section 137 onwards. So number one, first step, he can actually summon people, he can summon the complainant to come. Okay, for example, in the scenario just now, I had hit Mr. Gunn. Mr. Gunn is a complainant. So he can act like a police, He can ask Mr. Gunn to come and write down the particulars of this complaint. Okay, so this is provided in your section 133. Okay, so the purpose of this so-called examination is provided in one case. I think this is one good case for you to remember. Actually, there are two cases, if I'm not wrongly remember. One is Firasya Munusami. Another case is Hardia Singh against Farida Harun, something like that. So the object for this examination is only a preliminary inquiry. That means you get to know from the complaint what happened. Okay. Subsequently, if you think there is a case, there's a sufficient ground for you to proceed, then you ask me who is the accused to come with a summon or a warrant. Okay. This is pursuant to your section 136 CPC. So as you can see, police was vested with a lot of power of police and also PP. He actually took the charge to look into this case already. Okay. So other power is like he can also dismiss the case provided in your section 135 if there's no case. And he can also postpone the meeting of the accused or the complainant. This is by virtue of your section 134. Okay. I think nothing much difficult. And if it's, let's say, because the offense itself sometimes is not very heavy, isn't it? Sometimes the accused no need to come also can. The accused can actually plead guilty or send a surat wakil to somebody, provided the offense is not so-called carry the imprisonment not less than 3 months or both. So send a surat wakil or plead guilty by advocate or solicitor also can. Section 137. Okay? Can bro?
Thank you, Dr. Chee.
Can
Yes, there is a cognizance of magistrate lah. Okay. So I think we still have about 4 minutes left for our session. I think we'll open up for Q&A lah. Is it okay, bro?
Yeah, can.
Yeah, we open up for Q&A lah. So for before we proceeding to another session, so you just do Q&A now, and we can continue the rest lah. You can open your mic and speak lah. I think it'll be easier, rather than reading the text. Anyone, we have about 5 minutes for this. So we'll stay for about 5 minutes for the Q&A. If there is no questions from the floor, then okay, we have one question from Lee. Is accused entitled to their 112 statement? The answer is no lah, because 112 statement usually they won't give it out. Okay. When you done the 112, you will sign, you can't even take photos, and they will not give it to you. Okay. Even though by virtue of 113, you can impeach the credit of this witness, but not the credit of the accused. Okay, this is about 112. You can take it as a privileged document, privileged document. Yeah. Based on Siti Aisha, is stated can. But practically, it is not allowed, I can tell you safely. It's not allowed. Any more questions? You can turn on your mic and ask questions. Just one more. Does the court registrar have power to issue and sign search warrants? Normally, it's done by the magistrate. What is the difference between complaint and FIR? Complaint and FIR. You lodge a FIR, you lodge a complaint to the police, and it turns to an FIR. Is it correct, Chee?
Yeah, I think it's overlapping in nature. FIR is just the formality. I mean the
Formality, yes.
formal written down type of complaint.
This criminal procedure is actually, when you read it, it seems easy. So you have to focus on the application and also all the past questions. And the case list I've actually posted in the group. If you find it useful, you can use the case list. Consent and sanction. Okay, basically you put it this way. Consent is something which, if you don't get it from the PP, basically you'll be null and void your case. For sanction will be something less serious. You can put it this way. For example, I always tell my friends this way. These cognizance of magistrate, as you see, we have sanction, right? We have sanction. We should obtain a sanction from PP. So, because why? Because why you require only a sanction, but not a consent from the PP? Because the magistrate is somehow a qualified person, right? So you get sanction for cognizance. However, for consent, the threshold is higher. Police, OTI, this one is considered as a consent in order to investigate. Yeah? This is my 2 cents on this. So consent and sanction, you can put it this way. Chee, you got anything to add on consent and sanction?
Yeah, more or less, no. Consent, deeper consideration is needed, and you need full reasoning before you can give consent.
Explain search with warrant and search without warrant. Try. I believe it's this one, search with warrant and search without warrant. Okay. So, we have Mr. Reno joining us. Give a big thanks to him. These are his notes. Okay, a big shout out to him. So with search warrant, probably Mr. Reno, you can help to explain this. I believe you can explain it in a very detailed perspective. You see here. No, I explained already, bro. So now your turn. Can help us to understand more about this.
Hi.
Hello,
I cannot
bro.
show
Yeah.
my face. Because
Come,
I
come.
don't, I'm not
Yeah.
wearing shirt now.
Come,
Okay,
the floor over to you.
search with-
Explain a bit.
Yeah, for search with warrant, of course, it means literally the police go to your house with a search warrant lah. Without warrant means whether in the situation where they don't have the search warrant, whether they can search your premise or not. But I think you guys need to understand there are three types of searches lah, which means search on person and search of body and search of premise. So you will notice only search of premise, we need search warrant. But for search of person, person can be a wanted person or search for a victim. Let's say I go and make a report to say my parents hilang already for 24 hours. So we are looking for him. That one is search for person. But search of body means the police want to search your body to see whether you got a dangerous drug or weapon or something. That one is search of body lah. But since the question is search of premise, then I just focus on search of premise. So for search of premise, is with warrant, I think very easy lah. Which means the court also say, okay, I give you a permission, you go to search this house. But without warrant, I think the question mostly will ask in what situation a police can search without warrant? Let's say now we are discussing CLP. Can the police just suddenly go into your house and search your property lah? So basically the section you can refer is section 62, 63. If I'm not mistaken, I think 113 or something. If Mr. Kan show button there. A few sections lah basically. But if you look at the definition, actually it's quite wide. They can search your premise as long as they suspect you commit something. Or actually 63 is quite discriminate because if the place is occupied by a person who convicted before the court then they can basically just go into your house and search. Actually it's quite discriminate. And based on my experience, I think mostly they will ask about section 116B, which is whether they can ask for the password to access your computer. I think I saw a discussion in Facebook, they say if there's a roadblock, can the police search my handphone or not? I don't have any case law, but I believe by virtue of section 116B, they can actually ask for the password and check your phone. Yeah, they want to check your phone, see whether there's any let's say porn. Actually by right in Malaysia we are not supposed to have porn in our phone but I believe a lot of guys friends we have right? Yeah. Okay.
Great, bro. Thanks for the detailed explanation. So I think Mr. Reno had done a very good job in explaining the cases. So just a minute. I have to go back to his promotion again. Since he's here, then we do one more time promotion lah. Yeah, this is his handsome face. If anyone is interested in getting the notes we are sharing, you can scan the QR, make the payment. The payment goes to Mr. Reno lah. So he will send you the hard copy notes. Without his kind notes and permission, this class wouldn't have happened. So all thanks to him. So any further questions since our Sifu is here? We can have more questions in another probably 15 minutes.
Yeah, I saw there's a person asked about whether a registrar can issue search warrant or not. I think he asked this question is because of the past year questions but actually there's a case law I don't know if you guys know about the case law or not. There is a case law actually to say registrar can issue search warrant, can sign the search warrant some more. There is a case law I can share that case law in the group later.
So do we have any more questions? Okay, I don't see any questions coming up lah. So I think we will end the session here for today. So you look forward to the next CPC class. Oh, There is one more. Huh? When to invoke the 4 types of body search. Body search. Okay, this one, maybe Reno can explain a bit, help to on this, when to invoke the 4 types of body search as per the 4th schedule of CPC.
Oh, sorry, let me see where they ask the questions. You mean like in what situation they will use pen down search or street search or whatsoever?
Yeah, they asked it in the chat box. Yeah.
Oh, actually, I also don't know, honestly. But I think the details are like how they conduct, we can see in the 4th schedule or 2nd schedule, if I'm not mistaken. But they never ask when to use pen down or when to use which searches before lah. What I observe, usually they will just ask you what is the definition, and those answers actually you can find in the CPC lah. But honestly, I don't know how the police choose which type of search they will use lah. Honestly, I don't know.
So based on the past year questions, there has been no question of such of similar type, I believe.
I saw a question they asked previously, what is the difference between complaint and FIR? If I may, can I explain further?
Yes, please.
Okay, my understanding, what is FIR and what is police report or complaint, is like that. FIR is more like you go and make a report to tell the police this crime has been committed, okay? But on the other hand, police statement or the witness statement is more like a passive. It's like the police come to you and tell you on when, what time, what you have seen. Can you tell us? Then they make a report. So for me, FIR is like an active role. You go and do something. You go and tell the police. So the police alert there is a crime committed. But for witness statement or for section 112 segment, it's more like the police come to you and ask you, then you give a statement. So for me, it's like one passive, one active in regard for that. But like I say, not like I say, is there's a case law to say it's not a condition precedent for the police to start an investigation with FIR. Why? Because not necessarily every time must have a complainant, then only the police can open file. The police can open file based on different kind of sources. Can be informer tell him, can be based on he knowledge or he see Facebook or whatsoever. So that's why it's not a condition to have FIR before he open file. That's why we have a case, the Indian case, Kwawaja, I think. There's a case law.
Thank you, bro. So we have one more question asked by Miss Tan. May I ask what is the effect of illegal search? If you could enlighten us on this.
Illegal search in Malaysia, although the evidence obtained illegally, but it's still admissible. If I'm not mistaken, the case is Saw Kin Hai, SAW Saw KIN HAI, I think, yeah. Which means we don't really care how the police obtain the evidence as long as it's relevant, although it's illegal, but it's still admissible. It's still admissible under evidence.
Thank you. So I think, thank you, Miss Reno, for coming in, our savior, to answer a lot of the questions. I passed the CLP because of him, his notes and his tutorials. So I believe comes to an end of our session today. So as I said earlier, if you are interested in notes, you can scan the code. And thank you everyone for joining, and my apologies for not being able to cover all the topics, and there might be something which I don't know, my sincerest apologies to all. Thank you so much, everyone. Thank you for joining.
Thank you so much. You can off the recording, bro.
Just a minute, let me off it.